This program is brought to you by FreeKeen.com. FreeKeen.com features audio, video, and blogs chronicling the transition to a voluntary society. FreeKeen.com also has comments and discussion forums so you can be heard. FreeKeen.com.
Three active complaints here.
I have 5 here.
Yeah, there's obstructing government administration filed by Attorney McLaughlin.
Okay.
Resisting arrest.
Jerry Hashcock.
And disorderly conduct.
As a misdemeanor?
Yes.
Okay. And the
You riot is the no process. Underlying obstruction.
Okay. Do you have copies of your complaints there?
I do.
You need me to go over them again with you? Are you prepared to make an offer of proof at the state?
Yeah, I can.
All right. My understanding from the clerk is that you intend to waive a trial here and appeal and have the jury trial in Superior Court. Okay. You need to just speak up so the record reflects your response. All right. So these are Class A misdemeanors. You were arraigned sometime in September. You were entitled to apply for counsel in this court if you wanted to. And if you qualified a lawyer, would have been appointed to you in these cases, and you don't want to avail yourself of that opportunity. Is that correct?
Yes.
And you could have certainly hired your own attorney if you wanted to have represented yourself. The procedure here is that if you want to proceed under Rule 2.14 of the Keene District of the District Court rules, the prosecution will be required to make an offer of proof. You can waive your trial. If the offer of proof is sufficient to these offenses, in all likelihood a guilty finding will be entered. They'll make a recommendation for sentencing. You can make a recommendation to me as to what you think the sentence should be in light of the fact that there will be guilty finding entered. I'll note your appeal here. You won't have to do anything further than I'll make sure we have a proper address for you so that when the Superior Court notifies you, you'll go out to a proper address and you'll know about the hearing. Understand that? You will also be entitled to apply for counsel over there. If you change your mind and decide that you do want an attorney, the same rights will apply to you there. Understand that?
Mm-hmm.
Do you have any questions about this procedure, how we're going to do this?
I don't believe so.
Okay. All right, so we have a charge of disorderly conduct on July 18th, resisting arrest on the 18th, and obstructing government administration on the 18th. So I'm going to ask the prosecutor here to make an offer of proof.
Your Honor, the date and times alleged in the offenses. The Keene police responded to Central Square for a call of an individual drinking alcohol in public. After some interaction, an arrest was made. The individual was placed in a cruiser. The cruiser was parked on Main Street in Keene. Officers Collins and Moore of Keene PD and Officer Jason Thompson of the Keene Police. They were attempting to move the vehicle, drive to the police station for the function of conducting a booking of the person who was recently arrested for lawful possession of alcohol. At that time, the defendant went in front of the police cruiser, Officer Moore's police cruiser, and prevented him from being able to pull forward. Officer Thompson then went out to the front, asked the defendant to move. The defendant refused to do so and was ultimately placed under arrest. While attempting to seek arrest, the defendant was ultimately placed in the handcuffs, and upon which time, when the officers tried to move him to the police cruiser, he fell to his knees and refused to cooperate and refused to walk. Another officer, Officer Sergeant of the Keene Police, had to come over after a couple minutes of the defendant being on the ground in handcuffs and help drag the defendant into the police cruiser, where he was ultimately transported to the station for booking.
Based on the state's offer of proof, I think the state, you have witnesses here today?
Yes, I have pulled officers here.
The state would have been able to prove the case beyond a reasonable doubt this morning. You had a not guilty plea, make guilty findings. What's the state's recommendation?
Your Honor, the defendant has a criminal history in Indiana. In October 2008, he was charged with possession of drug paraphernalia. The case was ultimately...
That's here, it wouldn't be a crime. That would just be an ordinance violation.
I'm not sure what the Indiana statute is. It's ultimately on a diversionary track where it was dismissed, but he does have a conviction in October 2009 for possession of marijuana, also in Indiana. He was found guilty. He received a year suspended. He served 4 days in the House of Corrections. As I said, his time was suspended on 1 year good behavior and he received probation. I spoke to his probation officer in Hamilton County, Indiana. They have filed a violation as a result of this incident, and there is a warrant out of Cornwall City Court in Hamilton County, Indiana.
They indicate whether they have an intent to extradite?
From my conversations with the probation officer, it doesn't sound like it's extraditable. The state's recommendation, based on his record and the seriousness of this offense, whereby you're essentially blocking police officers from doing their duty, impeding them while they have a prisoner in the back, the seat of a cruiser, which in my opinion is a very serious offense. The state is recommending on the obstructing government administration 93 days at the House of Correction, 3 to serve, 90 suspended on 2 years good behavior with a $250 fine to pay. On the resisting arrest, 90 days at the House of Correction, consecutive if imposed, suspended on 2 years good behavior. And it's my understanding that the reckless conduct is an alternate theory. It's the basis for the obstructing government
Disorderly
administration.
conduct?
I'm sorry, yes. It's the basis for the obstructing charge.
So the state would only be permitted to get one conviction?
I believe so. The obstructing is based on his unlawful
conduct. The
conduct.
state would basically malprosecute the disorderly charge?
I'm not sure, Your Honor. The obstructing is based on the disorderly. That's the unlawful conduct, so I'm not sure if it should be null pros at this time or...
I'll place that on file.
Okay.
All right, that's the prosecutor's recommendation for dispositions here. Do you have a recommendation you'd like me to follow?
Yeah, I think all the charges should be dropped because I was exercising my rights in Article 10 and Article 1 of the New Hampshire Constitution.
All right, there were representations about your record. Were they correct, or do you want to correct the representations about the background here?
I believe they were correct.
What's your mailing address?
900 Elm Street, Manchester, New Hampshire. 03101.
03101. All right, so you could nail that. So that's the address we're going to send over to Superior Court. Obstructing charge, the sentence is 93 days in the House of Corrections, 90 suspended for 2 years on good behavior. Good behavior is typically defined as no felonies, misdemeanors, or major motor vehicle violations as defined in the habitual offender statute. 3 days are to serve, and is a fine of $250 plus the 24% penalty assessment for $310, and I've noted your appeal on that. So we won't set a date for you to go to jail or pay the fine. The other two sentences are identical with each other. It's 90 days on each. They're concurrent with each other. That is, they would run together if they were imposed. but they're consecutive to this one. So your exposure here today is 3 days to serve plus an additional 180 days, 90 on the first charge and 90 together on these two together. Understand the sentence?
Mm-hmm.
Sentences? All right, just keep, if you change your address, you need to notify the Superior Court over there and let them know what it is. Those other two cases have been actually, is the other one now prosecuted?
Yes,
The other two have been now processed. If you want to wait around for any copies of these things, you can ask for them at the window. Thank you.
thank you, Your Honor.
Are all 4 complaints active here?
No, Your Honor. The obstructing government administration filed by Attorney McLaughlin is active,
No.
as well as the disorderly conduct, the riot, and the underlying obstructing government administration.
Okay, this one has to be now prosecuted. All right, the clerk tells me that you also desire to exercise your rights under Rule 2.14 as far as waiving a trial here and having an assessment for jury trial in Superior Court. Okay, are you able to hear me discuss it with the prior defendant up here? Do you want me to go over that in detail with you again? Right, so you know that you could have applied for counsel here, you haven't. You could have hired your own attorney or represented yourself. You're electing to go forward voluntarily doing this today. You'll need to be in touch with Superior Court to make sure that you get the mail and any notices that are required if you want to follow. This is at your mailing address there. All right, so the state brought these complaints. It's their burden to prove beyond a reasonable doubt the disorderly conduct matter here. And it looks like you have copies of your complaints right there. Okay.
I think there's just one that
Disorderly conduct should have. Let me see your copy. Make sure it's in the list.
that was just this one. Yeah, but I think that's just.
I just want to make sure that yours are the same as the ones on the information. They are. These are the two that we're working with here.
I think that's the real one.
I believe it's Attorney McLaughlin's replacement.
This one and this one. These are the ones that are active here tonight. All right, so I'm going to ask the prosecutor to make an offer of proof with respect to the background, and then we'll make a recommendation for sentencing. You can make your own recommendations if you think I should do, and then we sentence you. In fact, they've established they could approve the case today. Guilty findings will be entered, and then you all note your appeal here on the complaints themselves.
Yeah, it's the same operation, Your Honor. The Keene police responded on the date and time alleged in the complaint to a call of an individual consuming alcohol in public in Central Square in Keene. The police responded. Ultimately, there was an arrest made. The individual was placed in the back of the Keene police cruiser on Main Street, and officers and more of the Keene police attempted to drive the cruiser to the police station for the official function of booking, at which time the defendant stood in front of the police cruiser and after being asked by Officer Thompson to move, refused to move, and was ultimately placed under arrest. Those are essentially the facts, Your Honor.
You have a recommendation for?
Yes, Your Honor. She has no criminal history that I can see. The state is recommending a concurrent sentence on both charges, 90 days at the House of Corrections, suspended on 2 years good behavior.
Do you have a recommendation?
I think the charges should be dropped.
The state's made an offer of proof that would have been sufficient to prove guilt beyond a reasonable doubt on each of the charges. So the sentences run together. They're concurrent. 90 days in the House of Corrections, those sentences are suspended, 2 years on your good behavior. disruptive behavior is defined as no felonies, misdemeanors, or major motor vehicle violations as defined in the habitual offender statute. I've noted your mailing address here. Again, if that changes, you need to let the Superior Court know. And I've noted your appeal on the record here. If you want any copies of anything that we took used today, you need to wait outside and we'll get them for you in 2 minutes. Any questions?
How long before it's adjourned?
I don't know how long it takes, and I wouldn't expect to hear anything for a couple of weeks. But I think if you call next week, they probably won't even know about this. We have to process it here anyway for a week. Okay.
Thank you.
Thank you. All right, I wasn't aware when we were up the bench earlier that there was there's no charges here. There's 3 complaints here for attempted committing a theft from a building. We're all November 6th. The purpose of the crime you committed is alleged that you committed an act which was a substantial step toward the commission of the crime, and that without authority you attempted to remove a book from the Keene State Library. And I guess there are 2 different books and 2 charges, and then there's a common law contempt alleging you violated bail conditions that had been imposed on July 19th. And these are all Class A misdemeanors. You are pleading not guilty today. You want to ask an attorney to be appointed for you?
I don't think so.
All right. Well, if you change your mind, you have to come in and fill out one of those affidavits. We're going to hear from the state on a bail recommendation. I'll hear from you about that. I'll make an order, and then we'll set up. I guess we're going to give you a trial date today. It might be premature to ask this, but I guess I know you've exercised your Rule 2.14 right earlier this morning on independent cases. If you wanted to do that, we could get it in earlier. It may be too soon for the state to make any recommendations or anything today. But that's an option that's open. Right. State recommendation.
You're according to the affidavit, Mr. Gilroy, on
I don't have an affidavit. I have a copy or something like that.
Mr. Gilroy was at the Keene State College Library, had attempted to exit the library when the alarm went off. He was confronted by one of the employees there about the alarm, was asked if he had anything, any kind of property from the school or whatever. He explained that he didn't. The employee of this college informed him that sometimes cell phones can set off the alarm. Mr. Gilroy informed him that he had a cell phone, and the employee asked him to take the cell phone out and go through the scanner again. At that point, Mr. Gilroy admitted to the employee that he, in fact, did not have a cell phone, and that it was a book that belonged to the college that he was trying to walk out with. The employee explained to Mr. Gilroy that he needed an account if he wanted to rent books. Mr. Gilroy turned around, did not get an account, went back into the library, got another book, tried to exit again, which also set the alarm off again, and it was discovered that he was trying to walk out with another book. Mr. Gilroy has some prior criminal history. I don't have it in front of me here, Your Honor. But I think
It was read to me earlier, marijuana possession conviction in Indiana, where served a brief amount of time on probation for it.
as well as he was on bail at the time.
Based on the charges.
It's stemming from military. At this point, the state would ask that some cash bail be posted, $500, that he not be at any Keene State College.
That's the recommendation from the prosecutor here. Did you want to say anything about, if you say anything about the case itself, it could be used against you, which puts you at something of a disadvantage at arraignment, but certainly welcome to say whatever you want to.
Okay. What I will say is that they asked me to come back and talk to me about the cell phone. Said, okay, so went through without my cell phone and it rang. Gave all of them to give my name, and that's what happened. So that's a big difference than what that affidavit makes it sound like.
Okay, what's the difference? Am I understanding?
Well, she said I went back into the library, got more books, and tried to walk out again.
And you say that wasn't the case?
Yes.
All right. Is that Manchester address, is that where you actually reside? Pardon?
No.
Where do you actually reside?
I unfortunately can't give that information. I don't have a residence in Manchester.
I don't follow.
I don't have a residence in New Hampshire right now.
Okay, so where did you spend yesterday? Where did you spend last night?
Do I have to tell you that?
Well, I need to get some information here. I'm not.
I stayed on Church Street.
This isn't the case of the century, but I need some cooperation. Otherwise, the state recommends some cash bail. I'd be inclined to go along with it.
Excuse me, sir. He can use my address for the address.
I see.
Yeah, I did stay at his house.
Huh?
I stayed at his house.
Well, we need to know where you are.
I don't know the address is. But he does.
Well, I guess the question is, I need to know if there's some kind of permanency to this.
No.
Where did you stay the night before?
I stayed in Manchester.
The night before that?
Manchester. Different places, actually, so. And I don't know the address of one of them.
Well, how much cash do you have on you right now?
I have no idea.
So, what's the fellow's name that you stayed with last night?
David Krause.
That's K-R-A-U-S-E?
He's hard of hearing. David, he's asking you to spell your name.
Okay.
Just stay right there to spell your name.
No, I asked him, that's K-R-A-U-S-E?
K-R-O-U-S.
O-U-S-E. And he's welcome to stay with you?
Yes.
And what's your address?
174 Church Street.
That's where you actually live?
Yes, sir. Apartment 1. Take your hands out of your pocket, please.
Okay, I just want to get, you can have a seat, I just want to get your address.
Okay.
And the books were recovered, right?
Yes, sir.
You have a valid driver's license?
I do.
It'll be $100 cash bail that you'll have to come up with. Not to commit a federal, state, or local crime on release, that would be a violation of your bail conditions. All court proceedings as required. Live at that Church Street address. Keep the court advised of any change in the physical address. The physical address changes. Your mailing address remains at 900 something, was it? What was that again?
Elm Street.
Manchester. That's for mail. If that changes, you need to let us know. You refrain from the excessive use of alcohol, no narcotics or controlled substances. Is anybody here able to put up your cash bail for you today, do you think?
Can't speak for anyone else, can I?
Well, I didn't know. I didn't know whether you had some conversation at the time about what the possibility is.
I didn't know anything about this until.
Well, I didn't either. Just for your information, this does not constitute, this occurred, this is alleged to have occurred after. Any questions about the bail order?
I don't think so.
Okay. Thank you. Given that that trial.
Are we taking him into custody?
Yes.
April 20th.
Unless somebody here can do it for him, then you don't have to bother.
All right.
April 20th.
If he wants to.
Yeah, I don't know.
In the process, we don't need to impose prosecution. It's just an arrangement.
That's someone who issues bail after the.
Before, yeah, bail commission usually is before an arraignment.
Yeah, it's like if the judge isn't there
I should be in Keene, New Hampshire with the Free Staters.